right, I guess most of you are still here today. Most of you have survived the first half of basic training. What we're going to cover today, which I'm sure that you've all been awaiting with bated breath, I'm going to teach you how to make the enemy, that is the judge on your case, behave himself. There are several ways to do this. Now, this right here, we're going to start with federal judges, federal situations. I'm then going to work my way down into Texas judges. But you got to understand one thing about a judge. A judge is supposed to administer the law. He's supposed to act as a neutral and impartial referee. There's a quote by Edmund Burke from the English Parliament. Edmund Burke was one of the few in the English Parliament who basically told George III, hey, why don't you let these people in the colonies go? You're just going to create more problems and we're going to lose anyway. And his quote was this: what you are entitled to in any adjudication by a judge is the cold neutrality of a partial judge. You'll see that quoted quite often in modern published opinions. You almost never get it. Most of the time the judge is biased either in favor of the prosecution or the establishment. Now I'm going to show you how to deal with that. First thing you have to understand about a judge in our society normally is not there as an impartial referee. He's there as a control agent. His duty is to administer the law. His art is to delay it. And that's a quote from a fellow in 1764. And what he actually does is he is sitting on that bench acting as an impartial referee in the guise of administering justice, but what he's really doing is attempting to maintain the status quo. And when you are a peasant and the royalty, the judiciary, is attempting to maintain the status quo, what you have to do at some point, you've got to draw blood in one fashion or another, and I'm talking about legally, and I'm going to get to the B-52 of the American legal system here directly. But I'm going to start, like I said, with federal judges. This is one of the little tricks you can use against a federal judge. This is Title 28, United States Code, Section 372, Paragraph C1. It was enacted in 1981. And what it is that you can file a complaint. All you have to do is pick up a telephone. You call the Circuit Court of Appeals. Here in Dallas, you're in the Fifth Circuit, you would call the Circuit Court of Appeals in New Orleans, and you ask them for the forms and instructions to file a complaint for judicial misconduct. Now, you got to be careful when you do this, because you can't just squawk about a ruling that you got in a case simply because you don't agree with the way he ruled, even if the jerk was totally out of line. What you have to be able to do when you implement this statute is show how the judge's behavior, number one, interferes with the orderly administration of justice, or number two, show that the guy's got a mental or physical disability and somebody ought to look into it. The primary problem with this statute is that when you file a complaint, say, against a federal judge here in Dallas, it goes to the chief federal judge in New Orleans. And it's kind of like, well, here are the people causing the problems, and you're going to complain to the people causing about the problems about one of their brethren of the bench. And as you may guess, you don't get too far with these things in most cases. I'm going to show you how to get around that. In most years, you'll get about 2,500 of these complaints. 2 of them filed by lawyers, the other 2,498 filed by pro se litigants. And so you can imagine how they dispense with them. Now, the first thing you do is when you complain about a judge and his behavior, how it's interfering with the orderly administration of the courts, how you think the guy's got a substance abuse problem. Remember what I showed you about his signature? The chief federal judge is going to look at it, and he's going to figure out some excuse to flush it. So then what you do next is you take the same complaint, you file it against the whole circuit, every judge in the circuit. Say, look, this whole circuit is corrupt. I have one of these I'm going to be doing up in the 7th Circuit directly over a speedy trial issue. The 7th Circuit's the only circuit in the United States that took a statute enacted by Congress and under speedy trial, and they engrafted their own thing. Well, let me explain it. The feds have 70 days from the time they bust you to take you to trial, and there's excluded time for motions, that sort of thing. Well, in this particular case I was working on, a fellow named Robert Barrett I mean, this guy is he just has not backed up. They've dragged him through 2 trials. Other people have pleaded guilty. Worst that's going to happen to him is he's going to be out next year. All the people that pleaded guilty in similar cases, sometime in the next century, they might hit the streets. In his case, they had 70 days to take him to trial. But the judge allowed another 30 days for him to file motions, which supposedly stopped the clock. It's the only circuit in the United States that does that. It was 85 days before they took him to trial, but they just arbitrarily scraped this 30 days off. So what we're going to do is we're going to file a complaint for judicial misconduct for this nonsense against the entire 7th Circuit, which gives us a real good possibility of when his appeal brief goes in on this case, we're going to get judges from another circuit to adjudicate it, which means this case is toast. Now, what you're also doing, if you pump enough of these things in and they're well done enough, you can wreck a judge's career. One, may not make too much difference, but remember, in all 11 circuits plus Washington, D.C., they only get hit with about 2,500 of these a year. I can tell you that in 1 year, I was personally responsible for filing 400 of these in the 9th Circuit Court of Appeals. I mean, I showed all these people how to do them, and when you go back to this particular year, 1991, and you look up the statistics, you'll see the 9th Circuit Court of Appeals got hit with 400 of these, and I think the next circuit got hit with about 183. That's one. Now, another thing you can do, that same title here, Title 28, this is called the All Writs Act. You can use it for writ of mandamus, and what you do is you ask the higher court to order the lower court to behave itself, either mandamus or prohibition. This almost never works either. However, both of these can be used as a setup, which is what I'm going to show you. Give you some other examples. Had a case in San Diego that we were squabbling about the federal grand jury being a rubber stamp, and a federal judge by the name of Judith N. Keep. Now remember that name because there's a real good possibility she's going to be off the bench next year. What we did in this case is she dumped the case on us. She said, well, the guy I was working for, she said, you don't have standing, you haven't been indicted, even though that prosecutors are threatening him with indictment, and they've done all kinds of stuff. And in the hearing that took place in open court this year, she turned to the prosecutor and she said, you realize that if you indict this man, we're going to have to deal with these issues. They were grand jury issues. So, of course, she threw it out, said he didn't have standing. You know, she said, like, come back when you get indicted. In other words, she thought she'd put the thing to bed. So what we did next was, now, watch this. This is really deadly if it's used right. Federal Rule of Civil Procedure 27B. What it allows you to do is continue discovery even after you have lost in the district court. Now, when you first look at it, you think, well, so what? You know, the judge isn't going to allow you discovery because he or she just flushed you anyway. So what good is it? I'll tell you what good it is. 27B is unique in all the rules of civil procedure in that if the judge denies you the right to pursue discovery when you have a case on appeal, you can appeal this separately. You get a whole new, fresh, shiny-faced appeal just on this one issue. Because you're supposed to be able to get discovery in a case to find out if you have a case. And what this woman did, and I'd never seen a federal judge make a boneheaded move like this before, instead of simply rubber stamping a denial and letting us take this up to the 9th Circuit Court of Appeals on a separate appeal, she went down to the clerk's office, pulled the motion that we had done out of the file, and mailed it back to this guy. Well, when you conceal or cover up a fact in a federal court or hide a document, hiding a document is a violation of federal law. It's obstruction of justice. Title 18, United States Code, Section 1503 and 1505. In other words, if we put enough pressure on this woman, there's a real good chance she's going to be looking at 10 years of her very own. Because even federal judges, there's a case from, this is going back about 20 years ago. It's called United States versus Fromm. You remember Squeaky Fromm pointed a .45 automatic at President Ford? And it's in 405 Fed Sup. I cannot give you the page number off the top of my head because some of this stuff just came up last night. And the phrase that you want out of here is no person, even a president, is above the law. In fact, that's the one we used on Janet Reno. Might have got the judge's attention on that one. All right, now, there's one situation. I came across another situation last night. I had a fellow I was helping on a civil rights complaint, and apparently he stepped on some pretty big toes, because when he went to court, he'd already had threats. The chief of police said, look, if you need, I'll put an armed guard outside your house. Filed this thing in federal court 2 weeks ago. The first judge that looked at it apparently threw up and recused himself. The second judge, I believe the fellow's name is Vollmer, down in Alabama, at this particular court hearing, he told this young man that if he didn't withdraw this, that he was going to cite him for contempt of court for filing this thing as frivolous. All right, well, if you read the complaint and you knew the background of this case, that was the one thing that it was not. Well, what this judge did, and I haven't got a copy of the transcript yet, so I can't say this is exactly what he did, because right now we're playing, he says, the judge said. I have not seen the transcript. I hope to get a copy of it, because if this went down the way this young man said it did, this judge, number one, contempt of court, you're going to find it right here in the federal courts. Title 18, United States Code, Section 401. Now, a lot of people go into court and they're like this. They're trembling about contempt of court. But you can only legitimately be jailed for contempt of court in one of two situations. Number one is you're actually in court and you are creating a disturbance so that they can't take care of their business. Number two, if a judge has issued an order saying that you must do so-and-so, well, if you don't follow the order, that's a contempt. They can jail you for that. There is no authority whatsoever for anyone to tell someone, you filed a frivolous lawsuit. If you don't withdraw it, I'm going to hold you in contempt of court. The proper thing that judge was supposed to do was simply dismiss it as frivolous. It would have gone up to the 11th Circuit Court of Appeals in Atlanta, and the next thing that would have happened, it would have come right back down. You simply cannot do things like some of these judges are doing and get away with it indefinitely. You cannot pull things out of the clerk's file. You cannot intimidate people saying, look, if you don't withdraw this frivolous thing. I mean, all the judge had to do legitimately was dismiss it. Then he could have taken an appeal. Apparently, he scared this kid so bad that the kid put in his own motion to dismiss. However, even that doesn't completely end the matter, because this young man still has two ways to go. Number one, here's another rule you need to acquaint yourself with. Federal Rule of Civil Procedure 60B. What this rule does is, even after you have lost a case at the district court level, for up to 1 year, you can get the judgment set aside for mistake, inadvertence, excusable neglect, fraud, or some other just cause. Now, I know this one works because I've done it more than once. Now, let's get back to this, this situation in Alabama. One of the first things you have to do is, when you have a hearing like that and you know you got shafted, a lot of people make a lot of mistakes. They call up the court clerk and they say, you want a transcript. Court clerk does not handle transcripts of proceedings. What you have to do is you have to find the name of the court stenographer who was on duty that day. You call her up, you say, I want to order a copy of this particular hearing that took place on a particular day in a particular case. And she says, okay, it's going to take me like 10 days, 30 days or whatever, and it's going to cost you so much a page, usually $1.50, $4 a page, somewhere in that neighborhood. Well, if this hearing went down the way this young man told me it did, the next place that this particular record should go is the United States Attorney's Office there in Alabama, and then next it should go to Janet Reno, and then we're right back to the Janet Reno trick. Now, one of the things I want to back up here a little bit on is I've had more than one person evidence more than a little confusion over implementing regulations for a statute. And then they quote some case law that says, well, the statute has to have implementing regulations. I think I can help clear up some of the confusion here. If a statute has to have implementing regulations, then yeah, it has to have it. But the statute will so state. Most statutes do not have implementing regulations that go along with them. And if you're quoting a case that says that the statute had to have implementing regulations before it could be enforced, let me warn you about one thing. One size does not fit all. If you have a case site that says a statute, look at the number. You cannot take one case site and say, okay, the statute, maybe out of Title 26, has no implementing regulations, and then just apply it like plaster to every federal statute out there. There are thousands of them, and there are 50 different sections of the United States Code, 1 through 50. So be very careful that when you read a case, that case only applies to that situation on that statute. One size does not fit all. You simply cannot use one legal principle and then just arbitrarily glue it on anything that you feel like. Now, the next thing I'm going to cover here, because this is my favorite. Oh, sorry, wait a minute, back up here. I've got to cover some of the Texas methods of dealing with things. From the Texas Constitution, we're going to go on Texas civil procedure very lightly, because you're going to find that you can simply buy like a paperback book. Last I looked, they were about $11 or $13, that will have all the rules how to move all the chess pieces. And then as soon as we get through with Texas here, I'm going to show you the B-52 of the American legal system. Now, first thing that I'd like you to be cognizant of, Texas Constitution has one hell of a provision if you know how to use it. And that's Article 2, Section 29. And what this says is everything in the Texas Bill of Rights is accepted out of the general powers of the government, and all laws to the contrary are therefore void.
That's Article 1, sir.
You sure?
Yes, sir.
Because it was Article 2 when I looked up in...
Article 1, Section 29.
Okay, well in that... Pardon?
Article 129, the Bill of Rights is...
Okay, well on the break, would you come up here and correct me? In fact, come on up here now and correct me in person, because if I'm wrong, I'm going to admit it. Okay?
I'm like some. In fact, I've got a copy of it right here. It's Article 1, Section 29.
Let me bring it up here so I can see it. Yeah, let me see it. Okay, where is it here?
Article 129, right there.
Man's right. Okay, I stand corrected. Okay, we'll cross out 2. Now, what you do is, the problem is, once you have this article, you've got to know what to do with it. It's kind of like a little kid with a .45 automatic. If you don't know how to put in the clip and jack the slide back and get the safety off, what you have is relatively useless. And by itself, this thing is useless. However, Texas, like 36 other states, has the same thing that the feds have, but there's a different number. And it goes under this. So the Texas statutes is this one here. And what this is that's the declaratory relief statute for the state of Texas. In other words, this is the equivalent of the federal statute I gave you earlier. Remember Title 28, Section 2201 and 2202? That's the same thing. What you do is you take this statute here, you wire it in with the Texas Constitution, and then you show a Texas court that you have a problem here in that this particular statute was enacted in violation of the Texas Constitution. In fact, there's a statute I can't give you off the top of my head. I believe I mentioned it yesterday. The fellow down here that when I got to looking at his case, what I saw is that the Texas legislature had put an issue on the ballot, which is the way you have to do things in Texas and most other states. The common people have to vote on a constitutional amendment. And what they did was they put a constitutional amendment on the ballot, but then they wrote up a statute that did not kick in until the amendment passed. In other words, they pulled a real fast one on the voters here. And that particular statute is void. Now, Texas civil procedure, remember I told you the federal civil procedure, they had something like 84 rules of civil procedure. Texas has 331. Now, I know you look at that and say, who can handle this? But if you get in the books that outline these, what you're going to find is that these 331 rules of civil procedure are not really that intimidating because they're broken down into 11 sections. And a lot of those sections just are not going to apply to you when you start litigating. Now, let's see, okay, there's just one statute here, just so that everybody's cognizant of this. Personal injury statutes in Texas are apparently 2 years. They're found under this one here, and that's Civil Law Procedure and Rules. And legal malpractice is covered here. They don't mention it in the statute. They kind of hide it back in the case law.
Read the statute.
16.003. 16.003.
And that's legal malpractice?
This statute covers legal malpractice. The statute itself does not mention legal malpractice. You've got to flip through the annotated cases to actually find it, because a lot of people think that legal malpractice would fall under something else like fraud, which in many states has a longer statute of limitations. But bear in mind, if the brethren of the bar can figure out some way to get one over on you, they will. All right, now let's go with the Texas court system. And they have district courts here. And here in Dallas, I'm not going to write these up on the board because there are a wad of these puppies. You've got, here in Dallas alone, the district courts, and those are the ones, it's kind of strange. They've got this hybrid system here. I don't think they've quite sorted out. You have county courts that if the jurisdiction exceeds $500 or less than $100,000, it's effective October 1st, 1991, you can park it there. But the district courts, which are also over $500, and we're talking about $519.06. Here in Dallas alone, you have the 14th, 44th, 95th, 101st, 116th, 134th, 160th, 162nd, 1964 to 195, 203 and 204, 254 to 256, 265th, 282, 283, 291 to 292, and the 298th District Court, just here in this one town. So your best bet is if you're going to sue somebody in this town, find out where he lives, call the nearest court, and ask the clerk where you're supposed to park this thing. Now, on Texas, yeah, you have something?
Yeah, just for clarification, please. You said
Sure.
something about it. 16.003.
Yeah.
I don't know which book to find that in.
Okay, hang on a second. Let me back up here. I believe that's the Civil Procedure and Remedies section, CP&R.
Okay.
Okay,
Because in Article 16 of that same Texas Constitution, it's got the general provisions, and it goes through the oaths and everything.
Yeah, no, this isn't the Texas Constitution. This is the statute law.
But we're talking about legal malpractice, right?
Yeah.
Well, the Constitution at Article 16 is talking about legal malpractice, too. Any officer that's holding an office that they haven't taken their oath of office. Mm-hmm. And that's what this...
Okay, but see...
So the two are...
Yeah.
Kind of.
Well, all I'm trying to do is just warn everybody it's when the statute of limitations is up. Okay? Now, apparently, under government, and this is, I love this Texas legal system because it leads right into what I'm going to show you as far as the B-52 of the American legal system. In Texas, in fact, next time I'm here, you're going to come up and give this section because you're probably better at it than I am. 74.053. Okay, now this statute in Texas apparently is the one that allows you to do what's called a peremptory challenge. You have to do it before the first hearing, before this case goes to trial. It only applies to civil cases, but it means you can walk in the court, you can look at the judge, say, "You wrong-o," and get rid of it. Now, the district courts, let's see, already covered that. Texas also has a code of judicial conduct. If you violate it, you're subject to sanctions by the, what is this thing? They change the name every 6 months. State Commission on Judicial Conduct. It has 11 members. There are only 4 non-judges. The rest are all lawyers or bureaucrats. But this particular section here you'll find at 34.002, and I got to warn you, normally when you use this judicial misconduct business, There may be a few exceptions. They don't pay any attention to complaints filed by pro se litigants because you're not part of the club. However, what you are doing is building a record, and sometimes that's all you can do. The Code of Judicial Conduct, they actually have it as part of the government code here. It's and the problem with this, some of this stuff, is they don't even index it. They don't even give you a number. What you have to do is, if you want to see, well, let me back up here a second. I'll give you a number that may work for you. Is if you go to this number here in the Government Code of Texas, this gives you everything you're supposed to do and everything the way everything is supposed to go as far as notification to the complainant. And it's a little strange when you read this because it reads like that what you're supposed to do or what's supposed to happen is it goes this way and that way, but then when you read the caption and then you read the body of the thing, they contradict each other. It's like they're trying to cover something up. Ma'am?
May I make a comment?
Sure.
Yes, if they will write or call the Judicial Conduct Committee in Austin, the office will send them a beautiful book that totally outlines how to file a complaint against a judge. Now, I've heard in the past they used to have us sign those things with an affidavit form, and now they say we don't have to have it notarized anymore. Someone has told me that if you don't notarize it, that they don't pay any attention to it. Do you know anything about that?
No, I don't. It probably wouldn't hurt, but my experience has been with most of these commissions on judicial misconduct is they pay no attention whatsoever to any complaint by any pro se litigant. Now, I'm going to show you how to deal with that. But you've got to go ahead and make the move because you have to exhaust all the bureaucratic nonsense before you do what I'm going to show you how to do next. And I'm glad you brought that up. Now, one of the things you can do here, when you're complaining about how a judge is behaving, you can compare his behavior in the third volume of Government, page 560, Vernon's Annotated Texas Statutes, and that will tell you, see, normally what you want to do is if a judge just gets up there and he looks at you funny, that's not covered by the Code of Judicial Conduct. But if he gets up there and gives you a hard time, he shows bias, favoritism, he's drunk on the bench, that is misconduct. And then what you do is you use that. In other words, just compare his behavior on the bench with Code of Judicial Conduct, and normally the way he's treating you is going to fall in there someplace. Now, let's see, we've got, okay, here we go, is power of impeachment. Article 15, Section 1, Texas Constitution, and Article 15, Section 8 gives you the mechanisms and all that. The problem with all this is you have to be a representative to make it work. Now, before I get to the next section here, I'm going to give you a quote. See if anybody recognizes this. Politics is war without bloodshed. War is politics with bloodshed. Anybody recognize that? Because now, where's it from?
I don't remember where it's from, but I do recognize it.
Okay, you do recognize it? Mao Zedong, quotations, 1966. Now, here's what we're going to do is we're going to show you how to wage war with the system, and let me caution you on something here. You've all heard, I know a lot of people get all upset and they say, well, it's, you know, you can't advocate the violent overthrow of the government. That's true. But there's no law against advocating the peaceful overthrow of the government. Okay? And that's what I'm going to show you here. What I'm going to show you is the B-52 of the American legal system, and when I first had my son type it up a few years back, he came in, his eyes were as big as saucers. He says, Dad, we're all going to jail. I said, why is that? He says, you've just shown us how to overthrow the government. Well, that may be true, but as long as you don't use violence, there's no law against it. Now, here's what we're going to do. Let's say, and I'm going to use this at the federal level because you'll see immediately it can also apply to the state level. But the problem is if we had a federal government that functioned properly, the people in the states couldn't hurt us. If you could sue judges under 1983, if they paid attention to when you got locked up under Title 28, Section 2254, that's habeas corpus for state prisoners, the fact is the state governments, the state bureaucrats, the state judges, they couldn't hurt us. All this corruption basically emanates directly from the federal judiciary. So what I'm going to show you here is exactly how to scrape a federal judge off the bench. It takes a little effort. Let's say you've been up in front of a judge and you know this guy is a creep and he's trampled all over you and he's violated his canon of ethics. He has violated his oath of office to judge impartially. That's grounds for impeachment. Anytime a judge violates his oath of office. Remember that Title 28, Section 453? Learn it by heart. Because every time you walk in an American courtroom and sit down in front of an American federal judge, it's like a friend of mine once says, you know, Brown, he said, it's even worse than you said. He says, I sit in this federal courtroom and I'm watching my country go down the toilet. That the violation of that oath is grounds for impeachment, you will find in the Congressional and Administrative News. It's a set of law books. You're going to find the law library. It shows you where the bills originated.
Gee, that's awful.
Here, geez.
Do that.
Do what?
Thank you.
Okay.
Try it again.
Okay.
Try it again.
Okay. Anyway, it's the U.S. Code, Congressional and Administrative News, page 6896, 1990. Now, you need to read this whole section because it shows you that people in Congress are well aware that the public is extremely dissatisfied with the federal judiciary in this country. Cases take years that should take weeks. The average guy can't afford to go to court. I mean, they're very, very familiar with the unhappiness of the public. They did enact some more statutes to make these people behave. Unfortunately, they threw them right back into the place where the people causing the problems were supposed to obey these laws, and it hasn't worked yet that I've seen. But all you have to do is, I'll give you a specific example. There's a congressman out in Nevada. His name is Ensign. I cannot spell his last name. May be spelled like a naval lieutenant, and then again it may not. So I'm not going to put it up here because I don't know. There's another one named Souder in Indiana, S-O-U-D-E-R. Now these are both Republicans. I like Republicans because they're easier to take out than Democrats, because with a Democrat they're merely degenerate, but with Republicans what you have is everybody who signed that contract with America, like I pointed out earlier, that H.R. 666 and all this other nonsense, they violated their oath of office. Now, this fella in Nevada won his district in the last election. He beat a Democrat. Now remember, this was in a Republican landslide by this many votes, and this is not unusual. All right? He won by 1,745 votes. That's out of like 200,000 cast. I mean, these people are in a very precarious position. Now, here's how you do it. When a judge has violated his oath of office and you have the documentation, you write to the congressman and you say, I want a bill of impeachment brought against this dirtbag. And of course, what's going to wind up happening is you're going to get some kind of self-serving pablum back from the congressman himself saying, oh, well, it's precedent. We can't do anything about it. In other words, the people making the laws, once the judges twist them and bend them, apparently are helpless in the face of this. One member of the House of Representatives can absolutely wreck the career of any federal judge all the way up to the United States Supreme Court. Remember the hatchet job that Gerald Ford, when he was just a nobody from Michigan, he was a member of the House of Representatives. He brought a bill of impeachment against Abe Fortas, who was up to be the next United States Supreme Court Chief Justice, and completely wrecked his career. Fortas had to retire in disgrace. There was too much heat on him. One congressman, one elected representative can wreck the career, and I mean totally wreck it, of any federal judge in his line of fire. And by line of fire, I mean this. If you have a congressman here in Dallas or in this area of Texas, the Northern District of Texas, that you're going after, don't go after him because he won't bring a bill of impeachment against some federal judge in Oklahoma. That's not going to happen. However, a local congressman can bring a bill of impeachment against anybody in the Northern District of Texas, anybody on the Fifth Circuit Court of Appeals, and anybody on the United States Supreme Court. The problem with this power is most of these current idiots in Congress have no conception that they have it, and if they find out, they don't have the gonads to use it. So here's what you have to do. Once you have written this congressman and he's given you the usual self-serving crapola, what you do next is this. You divide his district up. Now, they're in Indiana on this fellow here. Now, watch him. Mark Souder, he just beat out the incumbent Jill Long. If he doesn't get my boy out here pretty quick, he's political toast. At the next election, this guy will not even be able to rerun for dog catcher. Because here's what you do. You take the guy's voting record. Now remember what I showed you about the first article of the Federal Constitution, Section 8, Clauses 1 through 18, and you compare the legislation this guy has voted for against those clauses. And if the legislation that he's put his yes mark on does not match up, he's just violated his oath of office. Anyone who has voted for that House Resolution 666, anyone who has voted for the Brady Bill, the assault weapons ban, anything like that, NAFTA, what you're going to find is he violated his oath of office. In other words, he ran, told the voters he was going to represent them, and the first thing he does, he turns around and shows you that his word is no good. And there's been no better time in the history of the United States, the possible exception of 1932, than to put some of these people out to pasture. So here's what you do next. Now this individual here, there are approximately 11 counties that he represents. Now each county has a certain number of population. Largest county, you may have 100,000 people here. Smallest one, you may have 4,500. And the way you do it is like this. It doesn't cost that much, and if with a little help from your friends, you can almost always get the job done. Once you have done your printed piece of literature, on the outside of the envelope, this is particularly effective, right down here in this corner, on the outside of the envelope you put, will Congressman Mark Souder take away your rights under the Second Amendment to own guns and your other constitutional rights? So somebody gets this envelope and says, well, geez, will he or won't he? So they open the envelope and it says right at the top, of course he will. And then you go into your hatchet job. You show everything that this guy has done wrong. And you start here in the smallest county, and you buy a computerized mailing list. Now this is more thoroughly covered in my book, the Erwin Rommel School of Law, but I think I can give you the general idea here. And you call a mailing list broker. You will find them in the yellow pages of any metropolitan phone book. They have them here in Dallas. And you tell them, look, I want to know what the computerized mailing list, in other words, you don't have to go through the phone book. When they send you this stuff, it costs you like, anywhere from 3 to 30 cents a name. They're already on gummed labels. You just stick them on the envelopes. And if you go to the right printer, when he prints up your particular flyer that goes inside there, they can fold them and everything for you. In other words, oh, the other thing is you need a bulk mailing permit. Go down to the post office, get one of those, so it'll cost you 20 cents instead of 32 to mail these puppies out. And week after week, you send out 1,000 of these a week. Now, if you do this over a year's period of time, what you're going to have is you're going to have 52,000 pieces of this little hate mail floating around. And what's going to happen is other people are going to look at it. And normally what happens, see now this fellow here in Nevada, he's about to get hit with this because, I mean, look at the margin this guy won this election on. He's right on the precipice. This guy is walking on eggs and doesn't even know it yet, and he's making the deadly mistake of not doing what my man wants him to do. Now, can you imagine if you were a congressman who won with this kind of margin? Let me warn you, it does not work with congressmen who won by a 40,000 vote margin. There's not a whole lot you can do with that. You've got to attack first military principle. You attack at the enemy's weakest point, not his strongest. This guy in Nevada is weak. A guy that's won by 40,000 is strong. You're butting heads with him. Now, can anybody tell me, is anybody here going to sit here and tell me that under any conceivable stretch of the imagination, when 52,000 pieces of mail going out showing what a dirtbag this guy is over a 12-month period, does anybody think this guy has any chance at all of getting reelected? Well, of course not. Now, quite often what will happen is when this particular individual sees how much damage is being done to him, somewhere between week 3 and week 10, somebody from his camp, not him personally, but somebody's going to get next to you and say, hey, what's it going to take to make this go away? And all you have to do is say, man knows what I want, I either get it or the B-52s stay in the air. And what you'll find is once you have your name on this, I mean, I always put my name on these puppies. In fact, even like this guy I'm working for in Indiana, I just told his kids, I said, I want his name on it, I want my name on it. I want this punk to know who he's messing with. What will happen is that when this guy finally gets thrown out of office because he's got all the intelligence of a tree snail, What will wind up happening is that the next individual who beats him, when you write to the next individual or call him, it's going to be, well, wait a minute, I know what you did to the last guy. What do you want? All right? And in fact, I learned this trick from a farmer in Nebraska, about 15 years ago. What he did was they had a guy running for the United States Senate, and he was talking about how he was going to deliver for Israel. Well, that really made this farmer mad, because he said, well, this guy running for the Senate in Israel or in Nebraska? And so the farmer got a computerized mailing list of every head of household in the entire state of Nebraska. And this United States Senator went down in flames. I mean, that was the end. Now, we're real close to running up on this segment. All of you who have particular legal circumstances you want me to address, in the next break, bring them up here, park them here, and I'll address them one at a time. I'll also try to take care of your questions. Do we have any questions on this segment so far? Okay, I see everybody shaking their heads. Yeah, Peter.
Only to say that Chapter 24 in the book, Erwin Rommel's School of Law, is titled Saturation Carpet Bombing. And you will get this lesson in excruciatingly fine detail.
Well, there are also, and what Peter forgot to tell you, is there are also other methods that we designate as crossing the T, artillery and support. They are military principles that can be used either in the legal or political system. However, like I told you from the beginning, there is about a 15% overlap between this seminar and the book, but I don't have an entire week, and I'm sure your behinds would all get sore, to try to teach you everything that's in that book. That book's based on 19 years of my personal experience.
And we are the Erwin Rommel School of Law. Michael Brown and our associates, Dwayne Rogers and myself, are available on a fee basis as consultants on your particular legal dilemma. And the way you contact any of us is through me, Peter John Simpson, care of 4842 North Magnolia, Chicago. The zip code lurking on the street, 60640-4710. And we're connected telephonically to you at 312-878-0681. Our dedicated fax is 0682. We have an impressive catalog of useful tools for lawyerless litigators. Ask for the Erwin Rommel Information Pack. And we thank you. And we are back. This is case analysis time at the Erwin Rommel Seminar. Before we get started, we would first of all like to extend a thanks to one of our hosts, and that is the Anti-Shyster. The Anti-Shyster is America's premier legal reform journal, and the Anti-Shyster is at P.O. Box 540786 in Dallas, Texas. And as I recall, the zip is 75354-0786. And the office line is 214-418-8993. And we're going to thank Robert Fox at the beginning of the next segment, and we'll have all of his names and numbers for you too. We would also, the Erwin Rommel School of Law extends a very, very heartfelt mountain of thanks to John Seidler's Quality Tapes, without whose cooperation and very able and gracious assistance, this video production would have been absolutely, totally impossible. And for those of you on the video audience, the address is on the screen. John, why don't you lean into a microphone and give him your mailing address on the audio portion for the audio guys.
You can reach me at John Seidler at care of P.O. Box 79176, Saginaw, Texas, SAGINAW, and the postal code, as some call it, is 76179-TDC. And you can reach me by voice at 817-498-1988. And the fax is 817-232-8579. Thank you.
John Seidler's Quality Tapes has an impressive catalog of seminars on legal reform and legal issues for lawyerless litigators, and we highly recommend that you call or write John Seidler's Quality Tapes and get a catalog, and you'll be amazed and amused at what you'll be able to learn. And now we're going to do case analysis. We may play a modest amount of question and answers, so if this is your case, just step up to the microphone, and we may have Michael ask you a couple of questions as he gets into your analysis. About 1984, I got involved in an investment. The promoter arranged 100% loans for each investor, and after 2 to 3 years, the properties were sold by the school district for delinquent taxes. The bank sued me. An attorney advised me to sign another note for $146,000. The original note was for $120,000. I had already paid $60,000. I apparently paid an attorney. Is that correct? $60,000? No. I'm sorry. The original was for $120,000. I had already paid $60,000. I paid another $70,000 and stopped. Went to jail twice over this matter. What should I do? Yeah, turn your mic on, Michael.
All right, Peter, it'd be a whole lot easier if I had those things to read before we got, because I've got a stack of them here. What you've got here is you've got fraud, you've got legal malpractice, and when somebody sues you that's someone else's fault, you put in what's called a motion for interpleader. Now, I got to warn you about fraud. Fraud is as varied as the rainbow. If you want to learn fraud, you've got to go to American Jurisprudence, second series, look under fraud. There are 700 pages of the different types of fraud that the courts have already addressed, and a new one pops up every day. First thing you have to do with this case is the statute of limitations. In other words, how long ago did all this stuff take place?
How long ago did this take place? Is the gentleman here?
Yeah.
Step right up. Don't be shy.
Oh, it's ongoing, so it's an open.
Oh, okay.
It's
then
an open problem. Yeah.
Okay, then if it's an open problem, this attorney shafted you within the last 2 years here?
Step right up to the microphone, please.
Don't
Pull the
go-
microphone down and speak into it.
Yeah.
Yes.
This attorney shafted you within the last 2 years?
The one that advised me to sign the second note, no, that occurred about 3 years ago.
Okay, well, so you got a problem there. The only way you can get around that is called equitable estoppel. In other words, if the statute of limitations has run up, but somebody puts you to sleep or puts you off, or you can show that there's some reason you didn't file suit that had nothing to do with your own fault, such as an attorney telling you repeatedly, look, we're going to settle this, it's no problem. You're kind of out to lunch on this one, but on fraud, you've got a heck of a case. And in the future, and possibly you might even be able to do it now, anytime somebody sues you when it's not your fault, it's someone else's fault, you put in a motion for interpleader. That's like, this man here is suing me, and I say, wait a minute, it's not my fault, it's his. Okay? And that way you drag another party into the suit, and then it is now, if you've got it wired together right, 80% of it is his problem.
Would you like me to read these out loud while you read them?
I've got a better idea, Peter. Why don't we put them under this thing here, because I already read these. See?
Oh, I see.
The problem
Okay.
is we've got, I started to say that we had to watch this because I was going to be disorganized, but now I have some professional help.
You want me to read them while you
Yeah.
read them out loud while you read them?
Well, no. That's not necessary because the first one up here, all right, this guy got busted for carrying a weapon, all right? And so I'm reading the Texas Constitution, and it says here under Article 1, Section 23, right to keep and bear arms. Every citizen shall have the right to keep and bear arms in the lawful defense of himself or the state, semicolon, but the legislature shall have power by law to regulate the wearing of arms with a view to prevent crime. Anybody know what's wrong with this? Bingo, okay? This is where you use that declaratory relief statute I told you about, because this contradicts the way that you amend the Texas Constitution. In other words, this thing here has given the legislature the right to amend the Constitution. That's not the way it works, people. What this individual here needs to do is simply put in a declaratory relief petition asking that Article 1, Section 23 of the Texas Constitution ask the court not to declare it unconstitutional, but declare what is the law. Is the Constitution amended by the legislature or by the voters? You throw that one in there on this one, there's a real good chance they're going to start backing and filling. Okay, now, the next one, we've got a, okay, this one I'm a little familiar with. What you have here on this particular case, this guy was followed by a police car. He's blocked in by 2 police cars. Okay, first you have a seizure, Fourth Amendment violation, cognizable under Title 42, Section 1983. Son arrested for protective custody. Protective custody. If you get arrested for something that's not a statute, and let me do a little aside here. Anytime some bureaucrat comes up to you, or you're in the post office or someplace, and some bureaucrat is telling you this is what the law is, and he's misbehaving, say, what is your statutory authority for behaving like this? And a lot of times what you get is this glassy-eyed stare like, what do you mean, what statutory authority? You know, I'm a king and you're a turd, all right? I mean, that's the attitude these people have. And when you back them up on this one, what winds up happening is, wait a minute, what do you mean statutory authority? Half these morons don't even know what a statute is. And they don't know what their authority is. And the minute they get outside of their statutory authority, they've left themselves wide open to suit, because the legislature only gives bureaucrats certain amounts of authority. They cannot make up the laws as they go along, which is what a lot of them do. So if this man's son was arrested for protective custody, there's no such statute. He's got a 1983 issue. Again, this is for a seizure, false imprisonment, false arrest, search of the truck. You've got to be a little careful here, because the Supreme Court has eviscerated the Fourth Amendment in many cases. Charged a father, we've got a concealed weapons beef again for a knife, which is a work tool. The statute, I'm not familiar with this particular statute, but the statute cannot just blanketly say that, well, anything you could hurt somebody with is a weapon, because that would eliminate claw hammers, crowbars, about anything you went to work with. They have to be specific. He was charged with altering a government document, charged with no insurance. They never asked for any. Jailed, property release denied, property stolen. Okay, now we're under the takings clause of the Fifth Amendment. Remember that last clause in the Fifth Amendment I addressed to you? What this guy has is about a 5 or 10 count cause of action on the under Title 42, Section 1983 against the police. This one here, he was in jail 238 days, brutalized 7 times without an indictment, filed a Title 42, totally dismissed with prejudice. He couldn't file an appeal because of things that got in the road. This is a rather simple Rule 60B, which you're already familiar with. You just put in a motion to reopen the case on that. This is city foreclosed on my bond to pay the tickets. Now this is a good lesson here, because this would get thrown out of federal court, because this gentleman here has said the tickets, but I don't know what tickets he's talking about. I don't know where he got them, when he got them, who gave them to him, or anything else. And it's without a due process hearing after he had rescinded his signature and plea. Well, what I'm looking at here, they've refused to hear his habeas corpus. If he's on the street, that's understandable. Does he have an action against these 3 judges? The problem here is that judges are so hard to deal with that if you want to get even with them, and in Texas, I understand, now correct me if I'm wrong, are not judges elected here in Texas? Okay, so in Texas, you don't even have to go after the federal representative with your B-52. Just find out when this jerk is up for re-election. He'll have a much smaller district than a federal representative, and take him out legally. All right, this one here, this fellow here began work as a contractor in August. He's got a big urinating contest over a Social Security number. The owner, he continued to work for this fella, didn't get paid. Other people got paid. The people that you see here, it's the EEOC, Equal Opportunities Employment Commission. They're absolute death on these people. There's real good case law under this stuff, too. You just look this up in the index of West United States Code Annotated. First thing I'd do is I'd file a complaint with the EEOC. If they don't do anything, you have like 180 days after they don't get off dead center. And cases like this, once you sue an employer, they're almost impossible to defend against. I mean, it's just a question of like how long it's going to take. Come up to the microphone, sir, if you would, and we'll go from there.
Yes, I talked with the EEOC, and they said since I was a subcontractor that they couldn't touch the case. That was their wording to me.
Okay, did you find that they actually had case law or statutes to that effect?
They showed me the rules. I can't remember where it was, but they showed me where they got that.
Okay, so in other words, you're not an employee, so you don't fall under that?
Exactly.
Okay, then here's what you want to do. There are several things you can do. You can sue for fraud. You can sue for unjust enrichment, because under fraud, every state in the union has what's called the implied covenant of good faith and fair dealing. And once you step outside of that, you've left yourself wide open for a fraud action. So what you're basically describing is what you have is a state civil action for fraud. Okay?
Okay, thank you.
That's it. All right, next one here, we've got a wrongful death. It's a failing to do cancer treatment after hysterectomy, bleeding ulcer from overexposure to cancer treatment 10 years later, failing to recommend temporary colostomy, failing to give any blood thinning drugs to prevent blood clots from forming following colostomy operation of an inactive person. Okay? Well, something 10 years ago, unless this has been ongoing, this is not going to fly. But this number 4 here would come under medical malpractice. All right? And medical malpractice, and here's a little irony here. When you do a malpractice action, a lot of people wonder where legal malpractice came from. The hilarious part of it is it came from medical malpractice, because the lawyers created this monstrosity here many years ago, and then when they got to the big head and got to thinking of themselves as professionals instead of just scribble warriors and indexing clerks, then when they started calling themselves juris doctors instead of just, fact is they had a law degree, what happened was all the case law that the attorneys had developed on medical malpractice was moved right into legal malpractice. That's where it originated. And yeah, they kind of got hoisted by their own petard on that one. Now, next one, we have a real estate monstrosity here. And this is basically very similar to to an earlier thing that I did. This lady apparently was basically, what I smell on this whole thing here, it's a little lengthy to read. It's obviously over 50 words. But I think what this individual here needs to do is, again, go to Amgir Second. In those 700 pages of fraud, she's going to find her problem. Also, Corpus Juris Secundum, that's CJS. It's a blue set of books in the law library. Amgir Second are the green ones. But I want to tell you, about 1/3 of all the pro se litigation out there should be pled under here, and nobody ever does, because nobody knows anything about fraud, because nobody studies it. And almost anything, remember what I said about the covenant of good faith and fair dealing? Well, it's pretty obvious it wasn't applied here. If it doesn't fall within the parameters of good faith and fair dealing, you can sue for fraud. Now, normally, I got to caution you, in most states, when you sue for fraud, there are certain elements you have to satisfy. Somebody told you something, you relied upon that something, and you were injured by it. And make sure that when you plead a fraud case, you've got all those elements plugged into your complaint where the judge can recognize it, or you're going to wind up with a real good chance you're going to wind up with a motion to dismiss for failure to state a claim. Now, next one here, we've got internal revenue, tax returns audited 1981 through 1984. I don't know if what the years on this were, but there is a 10-year statute of limitations. The fella who had this one here, it says approaching bankruptcy. You'll get up here and tell me, your tax returns were audited 1981 through 1984. Has any civil action been filed against you on this case?
No.
Okay, bingo. Watch this. Okay, you go to Title 28, Section 2810. It's United States Code. you mount a preemptive strike, and what you do is you ask the court to quiet title on this. This is an action to quiet title. I just had one out of Colorado a couple of months ago. Whenever the IRS is past the statute of limitations, they have no authority to do anything. This one particular statute here covers a plethora of other federal statutes, and that's probably what you need to take this out.
I don't believe it's past statute of limitations.
Statute of limitations. Now, watch my lips. The statute of limitations for the Internal Revenue Service to bring a civil action against you for any type of a tax squabble at the federal level is 10 years. They've got you 81 through 84. This is 95. It's 11 years.
It was in tax court. And
Okay,
I understand the statute continues to run.
Okay,
till
yeah.
after the
Well, see,
final.
you don't have that here.
Well, yes, it did. I indicated that we went to tax court.
Okay.
They
Okay.
then,
When were the tax court petitions filed?
the tax court petitions were filed in 1987 and 1988.
And you're still dealing with this?
Yes, sir. It was 5 years before we ever went to trial on, and then there's about 25 issues in these audits. They took one issue and tried that approximately 5 years after we'd filed our petition for tax court.
Okay, wait. How many issues? You say there's 25 issues?
Yes.
And they only took
Addressed
one to trial?
They addressed
All right.
one, and then they scheduled another
Okay,
trial.
wait, stop. Is this on the same set of facts between the same parties?
Essentially, yeah,
Okay, no, just answer me yes or no, please. Is the second trial going to be on the same set of facts between the same parties?
different issues, but same tax return.
Same set of facts between the same parties?
Yes, sir.
Okay. Remember how to spell collateral estoppel? Just use collateral estoppel with this statute here, end of problem.
But
Okay?
they say they severed that one issue.
They can't do that. They have no authority. They can say they do anything they want. They can do anything they want. But if you use this statute here in collateral estoppel and say, wait a minute here, fellas, you already had your chance at me. You cannot piecemeal litigation. I don't care who you are, including the federal government. If it's the same set of facts between the same parties, collateral estoppel applies, civil and criminal. Okay? You cannot litigate the same issue twice.
How am I going to stop? They've been taking my paycheck since April.
I just showed you. There's the statute. Look it up.
All right, thank
Okay? And then once you do that, what you do with this one here, you only need that one set of numbers. Read the numbers, read the case law, read collateral estoppel, and I think you're going to see you do not have a big problem. Okay? Now, the next one here, we've got a district attorney promised a jurisdictional hearing in writing. There was no hearing. You know, the problem is this was a district attorney. If this had been somebody else who promised you something and didn't deliver and you got hurt by it, then you could get him for fraud. Unfortunately, these people in the government, district attorneys and judges, have what's known as sovereign immunity. The king can do no wrong. Okay? We've got 3 new tickets. Doesn't say what they're for. Signed nothing and demanded a PC hearing. I'm not sure what that is. Probable cause. Okay. Received false arraignment by oathless judge. The problem with false arraignment is that's a conclusory allegation. Why was it false? It has to be explained. Released to Dallas. Jailed another 1.5 days. I got to say one thing for this fella. You know, he doesn't strike his colors. He keeps at it. Released without signing paying. And there was another ticket hearing, filed refusal papers, didn't appear. Unfortunately, refusal papers aren't going to do you any good because we're right back to our 44 Magnum jurisdiction. And we have another fella here that's got a whole bunch of circumstances. There are 5 of them. There's no possible way I can address all these, but there are some things. Page 2, what he's looking at is possibly medical malpractice. Page 3, possibly the same thing. He had one real good one here. I think he had a... okay. One of the things here is that this, he's grousing about his name being misspelled. I think you're going to find that's under harmless error. It looks to me like... okay, bingo, here we go. Okay, this is the one I thought he could get some action on. A question, I just wonder how many other policyholders had this type of an increase. He's wanting to know, you know, how come he's getting charged extra premiums and the other people aren't. That's called bad faith insurance. I believe The anti-shyster is going to be carrying an entire article of mine on that. It's a very rapidly expanding area of litigation because most insurance companies, they either do not pay what their contract says they will pay, or they pull other stunts that are just not kosher. Now, the beauty of this here, if this is in fact a bad faith insurance claim, there's a 2-volume set of books by a fellow named McCarthy called Bad Faith Insurance. They're available, I believe, from Clark Boardman. They have offices in San Francisco and New York. And the beauty of a bad faith insurance claim is this. It's the one case that you can take into a federal or state court, and 99 times out of 100 you're going to win it because the judges look at this and say, we don't have time for this crap. There aren't any people who run these insurance companies voting in our district, so let's just toss it. It's the one, in fact, the last 5 I've had, I've won every one of them hands down. And boy, I wish I could say that about everything else. Pardon? The author's name again? McCarthy. Yeah, it's a 2-volume set. It's a little pricey. It's close to $200, but I got to tell you, this guy's been doing this for like 20 or 30 years, and he absolutely has his ball of twine together. Okay.
Clark Boardman Books is in the San Francisco or the New York telephone number. They are a large private corporation that market books on the American legal system. Clark Boardman Books.
Yeah, no, I'm not completely 100% sure what I'm telling you is correct, but you can call any company that sells law books, and if I'm incorrect, if it's from Whitney or somebody else, they'll tell you. In other words, I'm not 100% correct on this because I haven't had one of these cases in about a year and a half. Yes, sir.
Could I tell him how much percentage they went up on that?
113. Yeah, you did. Yeah, 113% increase in excess of 113% per month needs to be justified. Yeah, see, an insurance company cannot unilaterally alter a contract with you. And see, right there, you may have one hell of a bad faith claim. Let me give you an example of how deadly bad faith is. There was a case down in Alabama. I was reading an article in a law journal, and this fella, the insurance company stiffed him for $6,000. I mean, this was a nickel-dime case. And the attorney who wrote the article convinced the jury that the insurance company had stiffed all these other people, and so to punish the insurance company, they should give this guy more than the $6,000. What he got was $7.2 million in punitive damages. And it was upheld in the Alabama Supreme Court. Ma'am?
Yes. Should he also file a complaint with the Texas Insurance Commissioner, or just leave that alone and go through the courts?
That's a good question. The problem is, when you file a formal complaint with a state bureaucracy, they normally don't do anything. The beauty of the state insurance commissioner is this, is that if you sue, that's the same individual the complaint is going to go to, because in every state in the union, the state insurance commissioner is the registered agent for the insurance company if it's doing business in the state. And you cannot do business as an insurance company in this state or any state in the union unless you are registered with the state insurance commissioner. So you can take the exact same complaint, put a docket number on it, hit the state insurance commissioner with it. What he will then do is he will notify the insurance company that they're being sued, and once you have a judgment, here's the real beauty of this, once you have a judgment for bad faith against an insurance company, until that judgment is satisfied, they can no longer do business in the state. So they normally what happens is these bad faith cases pay off like slot machines. I mean, I could retire on bad faith cases if I could find enough of them. Yes, sir.
One other question on that. I was wondering what statute of limitation on this is.
More than likely it's 2 years. That's the general statute of limitations, but don't take my word for it. Remember what I keep telling you? The law is not what I tell you it is. It's what's in the books.
Well, it started 1st January this year, that increase, so I'm still within.
Oh, you're still paying it, right?
I'm going to quit paying the blasted thing.
No. Keep paying it and sue them. That way you'll get all your money back, plus you can get punitive damages.
Okay, I'll do that. I'll have a check in the mail before midnight.
Good. Okay.
Registered too.
Lift the stack.
Lift the stack. Okay. All right. Now this fellow here, this is kind of an unusual usual question. I thought I answered this yesterday, but obviously I did not do it well enough. This fellow wants to know, what is the difference between criminal and civil statute? How does a criminal court have jurisdiction over civil statutes? Well, criminal, you go to jail. Civil, you pay money. How does a criminal court have jurisdiction over civil statutes? Normally, any given court, federal or state, will have jurisdiction over both because they get mixed up a lot. You do not find courts in which you have a criminal court parked here and a civil court parked there. In Texas?
Yeah, municipal court has only jurisdiction over.
Yeah, come on, Al, up to the mic.
That question that he's posing references the municipal courts in Texas, which have jurisdiction over criminal cases up to misdemeanors and city ordinances.
Yeah.
They don't have civil jurisdiction, however, and our traffic code is in the civil statutes.
Okay,
that's
is anybody
what he's referencing here is how are they taking a civil question into a court that doesn't have civil jurisdiction?
Probably because they're getting away with it. This is the type of thing that we're right back to the declaratory relief statutes. If what I'm being told here is correct, and I have no reason to believe that what I'm being told is incorrect, but by the same token, I haven't read it, so I don't know if it's correct either. Once you read the statutes, if in fact what Al is saying is correct, somebody needs to straighten these people out in a higher court. And until someone does, they will just continue to get away with it. Pardon? No, it's not consent. I mean, you can, that's kind of like somebody holding a knife to a girl's throat and saying, now, are you consenting to rape her, aren't you? It doesn't work like that. Okay, now here we've got a regional IRS sent a notice of levy for which I do repair on a contract basis. Each Friday I submit an invoice for work done during that week, listing each repair and the charge for that repair separately with the total amount on the bottom line. A check is issued to me for that amount. Some arrears are to be paid off on the first of each month until liquidated. How can I lift the levy? I have paid no income tax since 1973 and been to the slammer twice, therefore. Well, you know, I know that a lot of people think they don't have to pay taxes, and I know a lot of people are going to disagree with me, but in my experience, the only places you find people who are out of the tax system, they're called homeless shelters, prisons, and graveyards. And the best thing you can do, rather than continuing to fight a losing battle on this, is just say, hey, look, can we settle this thing? Because you're going to find quite often they have bigger fish to fry than you. Let me give you an example. I owed the IRS $40,000 in, this is going back about 1986. I had a business in Utah that went belly up in a house that I lost. And so I went to Southern California, and I sued the IRS before I left, by the way. They took $371 out of my bank account, and I'm eternally grateful to them because they made me so mad that I sued them in federal court for running into my bank account and swiping my $371. And I did a lawsuit that made the papers all over Utah. I pointed out that on the IRS form that I had a Fifth Amendment right not to snitch all over myself. And the papers picked the language up, and I later ran an ad in Spotlight because it seemed to have gotten them off my back. And I must have sold 400 or 500 copies of that complaint at $10 a piece. So you can understand I was really grateful to the IRS for making me that mad because I'd have starved without them. So anyway, I went over to Oceanside after this IRS agent, in fact he was the head of the office, came out to my house, and I wasn't there, and he told my oldest boy he was there to talk to me about my 40 grand in back taxes. So he called a few days later and said, look, Brown, I went out to see you. Do me the common courtesy of coming in to see me. And I said, well, okay, common courtesy, I understand. So I went out there and I walked in, and I had this 1974 Lincoln. My kids called the Scuzz boat. I mean, this thing, tell you how bad this car was. A couple of girls out hitchhiking one day, and I stopped to pick them up, and they both looked at me like, this guy's driving Christine. And I had to tell them, come on, girls, I only do rapes and murders on Friday. It's Tuesday, I have to get to class. Okay? So they got in, we drove down the road. That's how bad this car was. So I drive up to this guy's office in this thing, and I'm wearing my tennis shoes and my rags and all that. And he sits me down and says, okay, Brown, what are we going to do with this tax bill? I said, well, what do you want me to do? He says, well, have you got any way to pay it? I said, well, it's a little difficult. And he said, why is that? I said, well, I'm an ex-convict and I got 9 kids, and I can't seem to get a job. And he just went, oh, jeez, you know, one of these. I said, look, but I would like to have you people off my back. Could we settle for like 10 cents on the dollar? And he says, you know, Brown, he says, I think we can do better than that. He went into the next room, came back about 5 minutes later, he says, you know what? He says, here's what we're going to do. We're just going to mark the whole $40,000 off as uncollectible. And so I really don't have anything against those people, and I got to warn you that if you keep butting heads, it's kind of like, imagine yourself as a feudal serf, and the lord of the manor gets a section of your produce or your livestock or whatever, and you decide all of a sudden that he's not entitled to anybody or anything or any food or whatever, but he's got all the troops, he's got all the weapons. The only thing that you can do here is you're going to get stuck with the money, but as far as going to the slammer goes, there's a good possibility you can shortstop that for the reason I gave you yesterday. Congress never had the authority to enact general criminal statutes under the 16th Amendment, but you absolutely have to have your ball of twine together on that one. Okay? Now, next one here, we've got a 1984, purchased a 5-acre salvage yard in Dallas. The license expired in 1987. City would not renew even though the yard had been there since 1957. Reason given is because it lies in the floodplain. I'm currently under contempt for not moving off the property. I want a license to operate or operate without a license. Well, if you've been deprived of something without notice or a hearing, or that's due process, or you're being deprived of property without just compensation, you're under the takings clause of the Fifth Amendment, this may be cognizable under Title 42, Section 1983. All right, statement of the case. Amazing. Okay. Now here's somebody who did it right. Okay. This man apparently, he must have learned something before he got here, and I talked to him. A civil suit pursuant to Section 801, apparently this is a Virginia State Code, wrongful death as a result of a guilty finding in a criminal case. Service for the case was improperly made on mother's residence and not my usual place of abode. Motion by attorney by special appearance with affidavit from mother to quash service was undecided as the affidavit was ruled insufficient and mother was not available to testify. I, the defendant, filed motion for continuance after removing attorney from case in March. I assume that means March of this year. Motion was denied and I notified by mail on April 29th for a hearing scheduled for 1 May in Virginia. Judgment was made in my absence. Well, they will do that, okay? Facts, notice of service left in mother's mailbox after man tried to deliver a letter of no big deal. He was told that son person did not live there. 2, all appearance by attorney was made by special appearance. 3, defendant could not get flight out to Virginia on weekend or Monday, 1st of May due to severe hail. You prove this one. I don't know what the statute is in Virginia, but in the federal courts it's Rule 60B, which we've already covered. Severe hail damage and large amount of flight cancellations all weekend. Defendant did not have reservations. 4, many people holding tickets were stranded in DFW for that weekend. 5, notified judge's clerk by phone and fax prior to court session of flight cancellations and again requested continuance. Relief requested, judgment reconsideration, or motion on due process. Well, this is a real sweet one here, because all this individual has to do is look up the state analog to Rule 60B in the federal level, and when the judge denies it, your time to file a notice of appeal is from that denial, not from when the original thing took place.
Would you repeat what Rule 60B is?
Okay, Rule 60B is you can have a judgment set aside for up to a year in the federal courts for mistake, neglect, excusable neglect, fraud, inadvertence, a whole bunch of different things. And this one here, if this were a federal case, this would be an absolute lock on a Rule 60B. In the state of Virginia, I suspect it will also work. But again, all this individual has to do is look up the Virginia Rule of Civil Procedure. In other words, just go right to the table of contents in the Virginia Rule of Civil Procedure, put in a motion to set aside judgment based on excusable neglect, give all the circumstances, give all the evidence. Then if the judge slam dunks you and says, no, you don't get another hearing, I don't care if 14 planes got knocked out of the sky, you should have been on one of them, then you simply file a notice of appeal within the time given for appeal. Now, I've got to caution you on something. Every state in the union has a different time limit for appeals. Now, most of them are 30 days, but like Justice Court in Nevada, it's 5 days. So you better know when you put this thing in, if this judge slam dunks you, how much time you've got to bring it up again. We've got the IRS is going to begin levy action against me on September 5th if an alleged amount is not paid based on a defaulted installment agreement made verbally over telephone. They declined a formal meeting with a PRO. All right, there's really not a whole lot I can tell here because I don't know how much the levy is for. I don't know how much the alleged amount is that wasn't paid. I don't know what the defaulted installment agreement made verbally over the telephone. Obviously, and I'm not advising you to do this, unless there's a tape recording, you could lie your way out of this one. I don't recommend it because one of the things you're going to run into is that when you lie in any agency proceeding of any agency of the United States, and this is particularly deadly in any type of executive proceeding, which is part of the IRS, they come under the executive department. It's a felony. It carries 5 years and a $10,000 fine. They lie all the time? Well, of course they lie all the time, but we are peasants and they are royalty. Royalty is allowed to lie.
Read that statute, Michael.
Okay, Title 18, United States Code, Section 1001. Violated all the time by federal employees, but if you violate it when you're dealing with them, they will bust your chops. I fell into foreclosure in my house due to unemployment and underemployment. I attempted to pay the note with a promissory note which was ignored. I contracted a life-threatening disease and almost died. While recovering, my house and all my belongings were stolen with the knowledge of the court. Well, the problem is you can't pay a note with a note unless you happen to be the federal government. If you have these green things that say Federal Reserve note, you can get away with it, but a promissory note is just a promise to pay, and you cannot use a note to pay a note with unless you happen to be the federal government. As far, pardon? Or a bank. Oh yeah, a bank. Well, what's the difference? I mean, can anybody tell me the difference between the American banking industry and the people who run the country? Kind of doubt it. All right, issue, unauthorized deductions taken from paychecks. I have never authorized any money to be deducted from my check for IRS. My employer, now ex-employer, followed IRS instructions sent to them in form letter to disregard my W-4 and take taxes out of my check. Unauthorized deductions totaled approximately $11,000 over 11 months. The problem that you have here is it's unauthorized according to whom? You know, people, I got to warn you that when you're dealing with the tax system, you've got no more rights unless you know exactly what you're doing, and even then it's questionable, than a medieval serf has. These people here, and you also, you can't do things like this because what you have to do, remember a statement of facts, conclusory allegations? Well, I've got this man's word that these are unauthorized deductions, but he doesn't explain why they're unauthorized. If they are in fact unauthorized, and you can show that by statute, then you're right back to that statute I gave you earlier, Title 28, Section 2810. Okay? Plaintiff works for the United States Post Office. While on the clock, October 10, 1994, he was instructed to go to the Home Depot for some parts. While there, he incurred a knee injury by losing his balance after stepping on the edge of a metal plate which was recessed in the floor. This injury resulted in surgery. Thus far, we have sent 3 affidavit notices to Home Depot, of which they ignored and defaulted. Shortly after default, an insurance adjuster for Home Depot contacted us stating they were not liable. Their first response, we demurred, and the second, we refused for cause. The case at this time rests. The problem is that I've got here is I don't see where the case was filed in the first instance, and there's another way to go on this anyway. You don't necessarily have to sue Home Depot. What you can do, if you happen to have an injury that was caused by somebody in the federal government telling you to do something or whatever, you'll do it under the Federal Tort Claims Act. In other words, there's a very simple form you call a United States Attorney, or you can call the Administrative Office of the United States Courts. And under the Federal Tort Claims Act, all you do is you just fill out a form, say, look, I was ordered to do this by my supervisor, I suffered this amount of damage, I want a specific amount of money. And what you do is when you send the form in, you just wait 6 months. You wait 180 days. If they don't pay you, then you take them to federal court. It's now cognizable in federal court. You don't necessarily have to do this through the state court system. Now, I've got one more here. This is a little longer than... okay, wait a minute. I recognize this one from yesterday. All right, I don't have to reread it. Oh, boy. Am I glad? This thing covers 2 pages. Okay. This fella here, and this is a criminal case, and the young man pled guilty. And I'm going to caution you again. In a criminal case, when you plead guilty, you can never again litigate the factual issues. There are 2 ways you can wiggle loose on a criminal case, facts and law. Once you plead guilty, you have waived all factual issues. I don't care how dirty the case was. You've waived it. What you have to do is get loose on a legal issue. And on a legal issue, how much time I got, Peter? 3 minutes. Okay, excellent. That's going to work excellent. All right. On a legal issue, there are a number of ways you can deal with things, and I'm going to show you one that I usually use in a state case. It works almost every time. You never get a clean win, but what they do is they normally figure out some way to clean it up so that it doesn't get published or get out, or they let the cat out of the bag, and it's this. Almost every state constitution has a provision that they can take you down in a criminal case via grand jury indictment or prosecutor's information. And on a prosecutor's information, that's just the prosecutor says, I think I want this guy to stand trial. But a grand jury, theoretically, has 2 functions. It makes an investigation, and it acts as a shield between the accused and the state or the federal government. Well, the state constitutions, now state constitution cannot violate the federal constitution. You'll find that in a footnote in Adamson versus California, the 1947 Supreme Court case I gave you yesterday. And the state constitution, if it conflicts with the federal constitution, is null and void. Now, my question to you is if I am indicted by a grand jury after acting as a protection or a shield between myself and the state, and the next guy that comes along, this young man here, was charged by prosecutor's information, and I had the protection of the grand jury, and he did not, can anybody show me where that would not violate the Equal Protection Clause of the 14th Amendment? And any sentence based on a violation of the federal Constitution is a nullity. That's been true since Zerbst versus Johnson, Supreme Court case from 1938. We got about, how many seconds we got here left?
Let me do the last 1 minute.
Okay, do the last minute, and people, it's been great. I may chit-chat with you a little later, but you're going to get Dwayne Rogers and a real dog and pony show next. He's going to cover trial strategy and tactics. What he's going to cover, I think you'll find quite entertaining. But as far as my organized presentation or disorganized presentation, I'm through for the day. Thank you.
The Erwin Rommel School of Law wishes to thank Ambassador Robert Fox, our co-sponsor today. If you would like to access very reasonably priced Blackstone's commentaries, Bouvier's 1839 dictionary in 2 volumes, 1914 dictionary in 3, please contact Robert J. Fox, Ambassador from Yahweh, care of 1209 Northwest Highway, number 268, a carrier route 4168 in beautiful downtown Garland, Texas, in North America. And Mr. Fox, in keeping with the money scriptures, wishes that you send substance or postal money orders only. We are going to take a short break. We're probably going to go to lunch. Regardless, when we come back, you are going to Dwayne's World, and we'll see you in a little while. Thanks.
Robert?